The court will calculate support based on all verified income sources, including real estate holdings, management fees, and trust disbursements. That was the line that made his hand stop mid-signature. But I need to back up. The morning his family's attorney called me, I was pulling a 48-hour shift in the emergency department at Newark University Hospital. I'd been on my feet for 19 hours. My scrubs smelled like iodine and stale coffee. I had just stabilized a teenager who'd been thrown from a motorcycle on the turnpike when my phone buzzed with a Manhattan number I didn't recognize. Miss Prescott, this is the office of Ashford Holdings. Mr. Ashford would appreciate a brief meeting regarding a private family concern, tomorrow if possible. I didn't answer right away. I knew what this was about. His son Julian had been seeing me for 11 months. We met at a fundraiser for veterans trauma care at Mount Sinai. I was there because I'd served 4 years as an Army flight medic, 2 deployments to Afghanistan, honorable discharge at 26. He was there because his family's foundation had donated enough money to get their name on a plaque. He liked that I didn't care about the plaque. I liked that he seemed embarrassed by it. He was 39, divorced once, no children, educated in that effortless way people raised in generational wealth tend to be. He quoted Hemingway at dinner, but couldn't change a tire. I thought it was charming, maybe it was. When I told him I was pregnant, he sat very still for a long time. Then he said, I need to talk to my father. That should have told me everything. The meeting was at Ashford Holdings headquarters in Midtown, 44th floor, corner office with views of the Hudson. The carpet was so thick my shoes made no sound. A receptionist offered me sparkling water in a glass bottle with the company logo etched into it. The air smelled like leather and money. Preston Ashford stood when I entered. Mid-70s, silver hair, posture like a retired general, though he'd never served. He wore a suit that cost more than 3 months of my rent. He shook my hand firmly. Miss Prescott, thank you for coming. Please, sit. He didn't waste time. A manila envelope slid across the glass desk. Inside was a cashier's check for $3 million, already issued, along with a non-disclosure agreement that ran 31 pages. Beneath it, a printed appointment confirmation for a clinic on the Upper East Side. Tomorrow morning, 9 a.m., Julian tells me this situation is delicate, he said. His tone was the same one I'd heard surgeons use before delivering bad news. Calm, practiced, detached. We'd like to resolve it quickly and privately. The amount is generous. The terms are straightforward. I looked at the check. $3 million. I grew up in a duplex in Paterson, New Jersey, the kind with aluminum siding and a chain-link fence. My mother worked 2 jobs after my father left. $3 million would have been another planet. You're asking me to terminate the pregnancy, I said. I'm asking you to consider what's practical for everyone involved. Practical. I've treated soldiers with severed arteries who showed more emotion than this man. He wasn't cruel. He was efficient. In his world, every problem had a price, and the only variable was whether the other party understood their position. Julian supports this? I asked. Julian understands the complexities of his professional obligations. That wasn't an answer, and we both knew it. I closed the envelope. I didn't touch the check. $3 million, I said. It's final. I nodded slowly, stood up, tucked the envelope under my arm. I'll think about it, I said. Something softened in his expression. Relief. He thought I was being sensible. He thought a girl from Paterson, New Jersey, who still had student loans from nursing school, would see that number and understand her place in his architecture. Very reasonable, he said. He had no idea who I was. I walked out onto Fifth Avenue and stood in the cold for a long time. Taxis honked. A woman in a fur coat nearly knocked me over with a shopping bag. The city moved around me like I wasn't there. $3 million for silence, for erasure. That night I didn't call Julian. I didn't cry. I sat on my couch in my 1-bedroom apartment in Jersey City and pulled out a business card I'd been carrying in my wallet for 3 weeks. A woman from my Army unit, a door gunner named Rebecca, who'd gone through a brutal custody fight after her own divorce, had pressed it into my hand at a reunion last year. Keep this, she'd said, just in case you ever need someone who doesn't flinch. The card read Diane Kovac, family law. 30 years of experience. Former prosecutor, she answered on the first ring. She sounded like someone who didn't sleep much and didn't mind. I was offered $3 million today to end a pregnancy, I said. Silence. 3 seconds exactly. Are you safe? Yes. Do you want this child? More than anything I've wanted in my life. Another pause. Then, how soon can you get to my office? The next morning at 8:15, while I was supposed to be checking into a clinic on East 63rd Street, I sat in Diane Kovac's office in a converted brownstone in Hoboken. She was 58, small, with reading glasses perched on her nose, and a voice that carried the weight of 1,000 courtrooms without ever rising above conversational volume. She read the NDA page by page. 15 minutes of silence broken only by the scratch of her pen underlining clauses. They're asking you to waive all claims to paternity, child support, inheritance, and future contact, she said finally. This clause here, she tapped the page, prevents you from ever publicly acknowledging the relationship. And this one revokes any right to name the father on the birth certificate. He called it generous, I said. She looked at me over her glasses. Do you want $3 million? I want my child protected. She leaned back in her chair. Then you don't sign this. You file first. I asked her what that meant. In New Jersey, she explained, once paternity is established through court action, child support is calculated using the state guidelines based on verified income. For high net worth individuals, that includes salary, bonuses, investment returns, trust distributions, real estate income, and management fees. Courts don't accept vague summaries. They require full financial disclosure. And if the respondent tries to hide assets, judges have subpoena power. She pulled out a calculator and a printed copy of the state's child support guidelines. She ran the numbers based on what was publicly known about Julian Ashford's compensation as a managing partner at his family's firm. The projected total over 18 years was considerably more than $3 million, and that was before healthcare, education, and discretionary adjustments for high earners. Here's the critical part, she said. If we file before they attempt to move this into private arbitration or mediation with a gag order, it stays under court jurisdiction. Public record, judicial oversight, that's their nightmare. Why? Because once it's in front of a judge, they can't control the narrative. They can't negotiate from power. They negotiate from statute. She closed the folder gently. What would you like to do? I thought about the soldiers I'd treated in Kandahar, about responsibility, about what it means to protect someone who can't protect themselves. I thought about a heartbeat I'd heard for the first time on a screen in a clinic in Jersey City, tiny and fast and real. File it, I said. She gave me a single nod. Good. Tomorrow morning, we walk into Bergen County Family Court, and somewhere in Manhattan, a very wealthy man is about to learn that not every inconvenience can be resolved with a wire transfer. Bergen County Family Court smelled like floor wax and burnt coffee. Fluorescent lights buzzed overhead. Plastic chairs lined the hallway. An older man in paint-spattered work boots studied a custody form like it was written in a foreign language. A young mother bounced a toddler on her knee while filling out paperwork with her free hand. This was real life. No glass desks, no sparkling water with corporate logos. Diane stood beside me in a navy blazer that had seen more hearings than I'd seen in trauma bays. She carried a single leather briefcase and moved with the calm of someone who understood procedure the way I understood triage. You're sure? She asked. I'm sure. She handed the clerk the paperwork. Petition to establish paternity, motion for court-ordered DNA testing, request for full financial disclosure. The clerk typed, stamped, and handed back the copies. The sound of that stamp, heavy, definitive, institutional, was louder than any check sliding across a glass desk. It meant we were in the system. Their system now answers to a judge. Outside, Diane made a call to a process server. They'll be served today, she said, at the Midtown office. I almost felt sorry for the receptionist who'd offered me that sparkling water. Almost. The call from Julian came that evening. His voice wasn't angry. It was shaken. What did you do? I filed a petition. You were supposed to. He stopped himself. Supposed to what? Disappear? Silence. My father is trying to protect the family. I'm trying to protect my child. There's a difference. We could handle this privately. You mean on his terms? He exhaled. He's going to be furious. He's going to be served, I said. There's a difference between those, too. After we hung up, I sat at my kitchen table, with my hands pressed flat against the surface. 9 weeks pregnant, no visible change, no movement, just potential. I looked at the envelope, still sitting on my counter where I'd tossed it the day before. $3 million. For someone who'd grown up watching her mother clip coupons and skip meals so her kids could eat, that number felt like escape. But I'd seen what happens when people take the quick payout. No enforcement, no accountability, no structure. And children born into disputes with powerful families need structure more than anyone. Diane called the next afternoon. They've been served. How did he take it? According to the process server, she paused. He went pale. I closed my eyes. That wasn't satisfaction. It was confirmation. For the first time, the situation was outside his control. The hearing date was set within 3 weeks. DNA testing ordered. Financial disclosure deadlines issued. No more quiet arrangements. No more assistant phone calls. Just a judge in a black robe and New Jersey statutes that applied the same way to a man with a 44-floor office as they did to the guy in paint-spattered boots. That evening, one final message arrived. Not from Julian. From Preston Ashford himself. 4 words. This was a mistake. I didn't respond because sometimes the most powerful answer is procedure. The preliminary hearing arrived on a cold Tuesday in early March. Bergen County Family Court, same fluorescent lights, same wooden benches, same quiet hum of ordinary Americans navigating their ordinary crises. When Preston Ashford walked through the metal detector, he looked like a man entering a foreign country. His suit was immaculate. His legal team followed, 2 senior partners from a white shoe Manhattan firm and a young associate carrying a banker's box full of files. They moved through the hallway like a convoy. Julian walked behind them. He looked tired. The judge was a man in his early 60s, wire-rimmed glasses, the kind of deliberate calm that comes from decades of listening to people argue about the most important parts of their lives. He reviewed the filings without expression, petition to establish paternity, motion for DNA testing, request for full financial disclosure. He looked up. Is there any dispute regarding potential paternity? One of Ashford's attorneys stood. No, Your Honor. No theatrics, no objections, just acknowledgement. The judge ordered DNA testing within 14 days. Then he addressed the financial disclosure request. Given the income representations in the filing, the court will require complete documentation of salary, bonuses, investment income, trust distributions, real estate management fees, and corporate compensation structures. I watched Preston Ashford's jaw tighten. For a man who'd built his empire on controlling information, court-mandated transparency was surgery without anesthesia. His attorney responded smoothly. We will comply, Your Honor. The judge nodded. This court's primary concern is the welfare of the unborn child. All motions for private arbitration are denied. Denied. That word settled over the room like a door closing. After the hearing, Preston Ashford approached me in the hallway. First time since the Midtown office. He looked smaller under fluorescent lights. You've created unnecessary complications, he said. No, I replied. I've created transparency. You could have resolved this comfortably. Comfortably for whom? He held my gaze. You've forced exposure. I've requested accountability. There's a distinction. Something shifted in his expression. Not anger, recognition. He wasn't dealing with someone who'd fold under pressure. He was dealing with someone who'd spent 2 deployments learning how to stay calm when the world was on fire. As he turned to leave, I heard one of his attorneys murmur to him, "This will be costly, costly," as if a child is an expense report. Diane touched my shoulder. You did well. I didn't do anything, I said. The court did. The DNA results came back in 9 days. Julian was the father. No dramatic revelation, no courtroom gasps, just a lab report filed and entered into the record. But that document changed the calculus entirely. Once paternity was legally established, the case moved from allegation to obligation. The financial disclosures arrived in stages over the following weeks. Salary statements from Ashford Holdings, bonuses schedules, trust fund summaries, real estate income from 17 commercial properties across 3 states, management fee structures. The numbers were staggering. Diane walked me through them in her office, line by line. Under the state guidelines, she said, child support is calculated as a percentage of combined parental income up to the statutory cap. For high earners, courts have discretion to go above the cap to ensure the child shares proportionally in the standard of living of both parents. Meaning what? Meaning your daughter won't live modestly while her father lives in a penthouse. That's not punishment. It's parity. 3 million suddenly looked like a discount. Julian called that night. This is getting out of hand, he said. No, I told him. It's getting structured. My father's board is asking questions about the disclosure filings. I'm asking questions about pediatric care and college savings. Silence. You're enjoying this, he said. I paused before answering. No, I'm enduring it. I didn't ask for conflict. I asked for accountability. A week later, we attended the Financial Compliance Conference. The judge reviewed every document. He asked Julian directly, "Are these figures complete and accurate?" "Yes, Your Honor." Preston Ashford shifted almost imperceptibly in his seat behind his son. The judge continued, "Given the projected long-term support obligation, the court will order temporary support pending final calculation. Structured, enforceable, court-monitored." Julian's attorney attempted a pivot. "Your Honor, the parties had previously discussed a private resolution." The judge raised a hand. "This court prioritizes the interests of the child. Private arrangements do not supersede statutory obligations. Statutory obligations. Law over leverage. Structure over silence." As we left the courthouse, Preston Ashford spoke to me one final time that day. "You've ensured maximum visibility," he said. "I've ensured maximum protection," I answered. "You could have handled this quietly. I could have handled it invisibly." That's not the same thing. For the first time, he didn't counter. He just studied me, the way you study something you've miscalculated. "I underestimated you," he said. "Yes," I answered, "you did. That wasn't pride. It was fact." In the weeks that followed, something unexpected started to shift. Julian began asking questions I hadn't anticipated. "What hospital are you delivering at? Have you looked into pediatricians? What about parenting classes? Do you think we should take one?" These weren't defense questions. They were participatory. Pressure reveals character. His father had responded with control. Julian, under the same pressure, began responding with curiosity. Diane noticed it too. "He's adjusting," she said. "Sometimes it takes structure to clarify what matters." One afternoon my phone rang. Not Julian, Preston Ashford. "I'd like to meet," he said. "In what capacity?" A long pause. "As a grandfather." That word hung in the air between us. Grandfather, not liability, not complication, grandfather. We met at Diane's office, neutral ground. He arrived alone. No legal team, no associate with a banker's box. He looked older than he had in March. Not diminished, recalibrated. "I've spent 50 years building something," he began, "and I've spent most of that time protecting it from anything I couldn't control." "I understand protection," I said. "But I confused control with protection," he said. "That's what you showed me," he continued. "My first instinct was to eliminate the risk. That's how I've handled everything for decades. Write the check, sign the NDA, close the file. And my instinct," I said, "was to make sure my child didn't become a closed file." Silence settled between us like something physical. "I was wrong to treat her as a problem to be solved," he said. That surprised me. Not the words, the weight behind them. We talked for an hour. Trust funds, education provisions, healthcare coverage, estate planning that formally acknowledged his grandchild. Nothing dramatic, just responsible. As he stood to leave, he paused at the door. "You filed first," he said. "That forced my hand. Yes, perhaps it also forced clarity." When the door closed, Diane looked at me with something between professional satisfaction and personal relief. "Pressure doesn't always destroy," she said. "Sometimes it rebuilds." My daughter was born on a clear September morning at Hackensack University Medical Center. No cameras, no announcements, just hospital bracelets and a single sharp cry that sounded braver than anything that had happened in a courtroom. Julian was there. He stood awkwardly at first, hands in his pockets, unsure of the protocol for holding something so small after a lifetime of managing things so large. When the nurse placed his daughter in his arms, something rearranged itself behind his eyes. Not calculation, not strategy, just awe. Preston Ashford arrived that afternoon. No entourage, no assistant, just a man in his 70s carrying a stuffed rabbit in a department store bag that he held with both hands as if it might break. He stood at the foot of the bed and looked at his granddaughter for a long time. "She's smaller than I expected," he said. "That's how they start," I told him. He stepped closer. "May I?" It was the first time he'd asked my permission for anything. I nodded. He held her carefully, formally, the way you hold something you almost lost before it existed. Hospitals strip away hierarchy. In that room, there were no board seats, no property portfolios, no non-disclosure agreements. Just 3 adults and a newborn. Later, when Julian stepped out to speak with a nurse, Preston stayed by the window. "I spent my entire career eliminating uncertainty," he said without turning around, "and I nearly eliminated something irreplaceable. You offered me $3 million, I said. Yes, to make her disappears. I believed I was managing risk." He nodded once. "That is accurate." He turned to face me. "When you filed," he said, "I was enraged. I called 3 different attorneys. I considered every countermeasure I could think of. And then I realized I wasn't negotiating. I was being held accountable. I haven't felt that in decades." He walked back to the bassinet and adjusted the blanket around his granddaughter's shoulder with surprising gentleness. "I've instructed my attorneys to revise my estate plan," he said. "She'll be named as a direct beneficiary, not through Julian, directly. You don't have to do that." "I know." "I was wrong," he said softer this time. "There's a weight to those words when they come from someone who almost never says them." "I didn't file to punish you," I said. "I understand that now." That evening, Diane called with an update on the final support order. Everything was in place. Structured monthly payments, educational trust contributions, healthcare coverage, life insurance naming my daughter as beneficiary, enforceable, transparent, court monitored. "Why didn't you take the settlement?" she asked. "Many women do." I thought about it carefully, because settlements depend on goodwill. Court orders depend on law. She was quiet for a moment, and law, she said, outlasts moods. "It's been 4 years now. My daughter is in pre-K. She argues about which shoes to wear and insists on brushing her own teeth, even when she misses most of them. She doesn't know anything about glass desks or manila envelopes or non-disclosure agreements. She doesn't remember a time before structure. We live in a modest townhouse in Montclair, not extravagant, not headline-worthy, just stable. Julian moved to the next town over when she turned 2. Shared custody became routine. Tuesday dinners, alternating weekends, school events attended without tension. The court order runs quietly in the background, doing its work. Automatic transfers, trust contributions, insurance premiums. No drama, just consistency. Preston visits every Sunday. He shows up without announcement, usually carrying something. A picture book, a set of watercolors, once a miniature globe. He spent 20 minutes explaining to a 3-year-old who was more interested in spinning it as fast as possible. The first time she called him Grandpa, he froze. Not in discomfort, in recognition. I saw it in his eyes, the weight of what almost didn't exist. One evening after my daughter was asleep, he and I sat at the kitchen table with mugs of tea. No legal binders, no folders, no negotiation. "I used to believe privacy was power," he said. "And now? Now I think transparency is what holds families together." He set down his mug. "I can't undo what I tried to do, but I can decide what I do from here. That's all any of us can do," I said. Julian has changed, too. Responsibility reshaped him in ways I didn't expect. He coaches her soccer team on Saturdays. He shows up 10 minutes early to parent-teacher conferences. He makes decisions without looking over his shoulder at his father first. He just makes them. Once, after a school concert where our daughter sang slightly off-key with tremendous confidence, he turned to me, and said, I was terrified of disappointing my father. And now? Now I'm more terrified of disappointing her. He nodded toward the stage where she was waving at us with both hands. That's growth, not cinematic, not dramatic, just real. I've thought often about the day Preston Ashford went pale. At the time, I assumed it was shock. Now I understand it was something deeper. Recognition that influence has edges, that accountability isn't optional, that control is not the same thing as care. The $3 million check expired in my kitchen drawer. I never deposited it. I kept a photocopy for a while, not out of anger, but as a reminder of how easily silence can be purchased and how much more valuable protection turns out to be. The law didn't humiliate him. It clarified him, and it clarified me, too. I didn't file to win. I filed because in this country, showing up matters. Filing first matters. Understanding your rights matters, especially for women, especially for veterans, especially for anyone who has ever been told it would be simpler to just walk away. Sometimes walking away is strength, but sometimes standing still is stronger. If you're listening to this and you've ever been pressured into silence, financial, emotional, legal, know this. Structure is not aggression. Accountability is not revenge. And protection is not selfish. It's the most responsible thing you can do. My daughter doesn't know the details of how her life began in a courthouse. She just knows she is wanted. Legally, emotionally, completely. Preston Ashford still moves with that measured precision of his. But when my daughter runs into his arms on Sunday mornings, he doesn't calculate. He doesn't strategize. He holds on. That's the difference between control and connection. And sometimes it takes a courtroom to teach a billionaire which one matters more.